At Cascade Legal. I'm here with our lead family law attorney, Will Jones, to talk about how to get a sexual abuse protective order, sometimes called a SAPO. So, Will, how you doing today?
Not too bad. Just sitting in my office watching the rainfall outside. That's what happens. Well,
It's
welcome to the Northwest.
welcome to the Northwest. As long as it doesn't turn white, I'm totally okay with it. So, today, let's talk about the sexual abuse protective order and kind of start with the basics. What are the requirements of being able to get a SAPO?
So start the whole thing off by saying these are fairly uncommon, right? Sexual Abuse Protection Act restraining order is kind of a result of some holes in some other areas of law. So your most common restraining order is called the FAPA, Family Abuse Protection Act restraining order. What this does is fill some holes that didn't exist in the FAPA order, which kind of changes some things. So it gets a little bit tricky on how you deal with this because a lot of the relationship requirements are going to push these into a FAPA, right? So this kind of goes, a FAPA doesn't quite cover that. So we've invented this other restraining order that does. So it gets a little odd when you start talking about it. So first thing, age requirement, you got to be over 18 basically to appear in court, right? So anybody over the age of 18 can get one of these. If not, if somebody is a minor, then they have to have a guardian or a guardian ad litem. That's someone who basically speaks for them for these proceedings. So almost anybody can get these. They just may have to have someone petition for or with them in that capacity.
Right.
So once you have that piece, which is basically everybody, you can apply for these. Then you start talking about the relationship requirement, which really in the this context is an anti-relationship requirement because FAPA takes things like intimate sexual partners, cohabitation, things like that. FAPA grabs those. So we're going to grab everything else with this SPO restraining order. So these people cannot be, or the alleged abuser cannot be your spouse or former spouse. It's going to be over in FAPA land, right? An adult related to you by blood, adoption, marriage. So cannot be for an SPO. That means you're back over in FAPA, right? Because they would grab them there. Former sexual partner, again, FAPA grabs that, not the SPO. The other parent of your child, you have a child with someone, that's back in Family Abuse Protection Act land. So this statute really carves out relationships and kicks you to another land. Person you were living with and having sexual relations, intimate family member, household member, you have to be contacted at least 2 separate times by the respondent within the last 2 years, right? So it gets a little bit, I don't want to say foggy, but the way that this is written eliminates people and puts you into FAPA land. So kind of odd in the relationship requirement. It's kind of an anti-relationship requirement
Yeah,
here.
that makes sense. It makes sense. It's sort of like you said, it's the not family of a FAPA. Um, so what sort of abuse are we talking about? I mean, it sounds like a stupid question because the thing says sexual abuse, but how does that sort of work out in layman's terms?
So it has to occur within the prior 180 days of you filing your petition, right? As we talked about in some of the other restraining order videos, things that happened outside of the 180 days are still relevant. They don't meet the statute. That doesn't mean you can get the order. But if you're talking about a pattern, if you have one instance within the prior 180 days, the ones prior to that or outside of that time frame may still be relevant. They may not qualify for the order, but they may be relevant to show, hey, this is a pattern and it's happened within the prior 180 days. So abuse itself is sexual contact, right? So just plain straight away sexual contact. Obviously, that can be a little tricky factually. Don't want to get too graphic, but what is sexual contact? Obviously, we've had presidents who have discussed this, so
Because they asked
it's
Bill Clinton.
it's a little odd. But it's sexual contact that either the petitioner didn't consent to. That's one piece that seems fairly obvious. But the second prong of this, or another path, the petitioner was incapable of consenting to due to age, mental incapacity. So you can see where this could turn into the petitioner was blackout drunk and could not consent to anything,
Yep.
right? So it's either didn't consent or was unable to consent.
If just go back to the 180 days real quick, let's say something happened, you were sexually abused, police came, person was arrested, person went to jail for a year, person's out now. Can I still get one? It's not 180 days, it's 180 days plus 365 days.
Exactly. So the law kind of carves out, I don't want to call them weird exceptions, but kind of obvious exceptions, right? So person's in jail, right? What do you need the restraining order for? Right? They can't contact you, they can't sexually abuse you, they're behind bars, so that's not going to happen. So anytime they're in jail doesn't count, right? Same thing if they live more than 100 miles from you, that time doesn't count either because they can't do this from 100 miles away. If there's another restraining order in place, such as a FAPA, for the time that that FAPA is there, that doesn't count for your 180 days either because they're already restrained from you. A criminal no contact order, which is sometimes part of a release agreement for someone who's done something bad, that doesn't count either. So your 180 days can be extended basically when the alleged abuser, has already been restrained.
That makes complete sense. It's like, there are other mechanisms in or reasons in why it may not be happening. So don't, punish you because of that. I like that. I like that. So again, we talked on some of these about looking backward and taking relevant stuff, and then now looking forward. I mean, does the fact that it just happens alone mean you can get one? Or do you have to be, threatened to continue to get sexually abused?
So the trick in any restraining order, no matter which one you're looking at, is if you have something that happened, right? It's happened in the past and that's terrible, but it's happened. We're not trying to remedy that in any way in a restraining order. There's all kinds of civil cases you can bring. There's all kinds of criminal stuff that can happen to punish people. Those things are all true. But anytime you're looking at a restraining order, we're going forward, right? We're trying to protect someone moving forward, which just like the 180 days being extended because somebody's in jail, we've eliminated the threat. It's restrained. That's why we extend that period. So in this context, you have to have a threat of continued abuse because that's what we're trying to prevent. If we're not preventing that, well, what's it matter, right? That's not what a restraining order is for. It doesn't redress wrongs. It tries to protect future harm. So you have to have that continued threat.
Yeah. So you've got that, you qualify. How does someone go about getting a sexual abuse protective order?
So forms are available through the Oregon Judicial Department. If you want to look for them online, they're a little bit harder to find because, like I said, this is much less common than a FAPA. And if you type restraining order in Oregon into Google, you're going to FAPA all day long, right? Because these are a little bit more rare. Once you have the forms, which the court can provide for you, you fill those out, say how you were sexually abused, when, why it was within the 180 days, all that stuff. Once they're filled out, you go to a proceeding called ex parte. Ex parte means only one party appears. So the abuser doesn't need to be there, probably shouldn't bring them with you anyway. Judge is going to sit there in ex parte and either ask you some questions or not. They don't have to. They may just look at your paperwork and go, this qualifies, this doesn't qualify. If it qualifies, the judge is going to go ahead and grant the order. If it doesn't, they're going to deny the order and you're done. If they deny it, that doesn't mean you can't go back and reapply. But for the time being, that petition is now gone. If it is granted, then you need to have that served on the other party. Until the other party is served, there is no effect to the order because they don't know it's there. They don't know that the order exists. So until it's served, there's no impact. You get the order, you don't serve it, you don't have a restraining order, no one is restrained, you just have a shiny piece of paper. So once it's served, then it's in effect.
You're served, the other person is served, the respondent. They obviously, I imagine, have a chance to object and have a hearing, don't they?
In most counties, there's no need to request a hearing, right? The court is automatically going to go ahead and say, hey, I've granted this order, it's served, we're going to go ahead and set a contested hearing date, right? That can vary a little bit because local rules can kind of deal with things, but according to the state, the judge is supposed to automatically set a hearing date, right?
Got it.
So hearing date, everybody gets their notices mailed to whatever's in the addresses or in the pleadings. Then the hearing's off and rolling, unless it gets continued or something like that. But the hearing should automatically happen.
So when it happens, I imagine both sides come in, they tell their story, they present evidence, and at the end, if the judge believes one or the other, what happens after that? How does it continue?
So first thing, people need to show up for these hearings. You get a hearing notice, go. You wouldn't believe how many people call in and go, I had a restraining order hearing on any type of restraining order. I didn't go because I didn't know what to do when I got there. There's not much I can do because I don't even have a court record to attack. This person didn't appear or didn't have an excuse other than I didn't want to go.
Right.
So at the hearing, the judge is going to hear evidence on both sides. Hey, what happened? What didn't happen? Is there unwanted sexual contact? Were you unable to consent? Tell me why, all that stuff. Assuming a judge finds that all the elements that we talked about earlier are met, the order is going to continue. Assuming a judge goes, no, I don't think this is exactly what happened, I'm not going to issue the order, or I'm not going to continue to uphold the order, it's dismissed. Everybody's free to contact each other.
So the petitioner wins. How long does the order remain in effect?
So SPOs are for a year when they expire.
When you say a year, what do you mean? Is it a year from that hearing where the order was continued, or a year from when you first filed it, or when it first went into effect, or when it was served?
Generally, it's when it first went into effect. There's always some argument because Odyssey, which is the court database system, things may not get processed on the day that they got there and end up in the registry. So there's obviously a little bit of which date are we going to use, but usually those dates are so tight that it never really turns into much of an issue. It's kind of we're within a couple days, and you could argue it that way, or you could argue it that way. So technically, it's a year from when it went into effect.
Got it. I know a lot of restraining orders, or some others, they can be extended. Could a sexual abuse restraining order be extended?
Generally, no. You could have some exceptional circumstances, but generally, no.
Got it. And so, what happens when someone violates it?
Then, so assuming somebody contacts the police, because these aren't magic papers, they'll make people disappear. But assuming someone contacts the authorities, they look in leads, they see the order, they see that it's been violated, automatic arrest.
Got it. So they don't get the right at that point. The police aren't there to say, okay, what happened here? This, that. Oh, let's think about whether it really was violated. If there's a restraining order, you're going to jail.
That's how it's supposed to work. What I tell most people, the further away you get from the courthouse, the less my predictive powers are. Because I've been pulled over by the police, clearly speeding. I knew I was speeding. The guy pulled me over because I was speeding, and he didn't give me a ticket, right? So the police have some discretion. Every now and then you'll see something like, oh, I just drove by the person I have a restraining order against. They were within 150 feet of me, arrest them. Most police are going to go, no, you drove past them. They were just walking their dog, and you knew that was going to happen. So they do have some discretion, but if they see that it's violated, what the law says is instant arrest.
Okay. Got it. Well, thank you once again for sitting down to talk with us. This time about how to get a sexual abuse restraining order. All of these restraining orders we've been talking about are a little bit different. have their own sort of niches. And I think the big come away from this is to talk to an attorney because, you may be going to file the wrong thing and then just wasting your time and potentially putting you in danger, or you may, on the other end, be being accused of something that is the wrong thing. So thank you for joining us today.
Happy to help, Steve, anytime.
Oh, anytime sounds good with me. And everyone else, thank you for joining us today. If anyone has further questions, please feel free to contact us. We will get you connected with an attorney who can help you. Stay safe.